Good afternoon. It's Thursday afternoon, March 2nd. There's 1 week of session left. I'll give you an update. I'm just going to go through House bills and then by number and then to Senate bills rather than skip all over the place, although even as I say that, I'll probably do some skipping. House Bill 1032, that was the initial child support adjustment. It's been 8 years. That came through 12-zip through House Judiciary, was killed on the House floor. They refiled on the Senate side. That would be Senate Bill 141. I'll come back to that, so it's still alive. 1053, House Bill 1053, that's the rural lawyer recruitment adjustments, so cities, small towns like Wall, Groton maybe, Alexandria, could elect to come in on their own to participate separate and distinct from the counties, and that passed. We're done with that. That finished. It's down on the governor's desk. House Bill 1080, that's the access to digital assets. We supported that bill. It likewise is down on the governor's desk. The Mineral Trust Bill, that's House Bill 1081. That was our bill, and it's passed and been signed by the governor. 1083, well, that's a big one. I'm going to wait for, that's kind of the frosting on the cake. That's the filing fee for equal access to the courts. I'll come back to that. House Bill 1183, that was the mental health revision. You may recall, if you followed in the media, delays of 4 or 5, even 6 months to have a criminal defendant evaluated to find out whether or not they're competent to stand trial, converse with defense counsel and so forth. We supported that. That also likewise passed yesterday afternoon. 1139, that was an adverse possession bill which we opposed. That was killed. Shared parenting, that was 1203, House Bill 1203. It was the mirror of Senate Bill 72, which was filed first. We killed that on the floor, 21-14, and then the next day the House Prime filed it as 1203, same bill, and that we killed in committee last week. Then we have, I think we're ready to go to Senate bills. Senate Bill 72, that was the shared parenting that we killed. Senate Bill 127, that was an adverse possession bill. That was slightly different than the House version, but that one we also killed. Now on those 2 adverse possession bills, what I promised to do, and I'm going to try to do this at the annual meeting, is to get some of our experts in real estate law that also understand the ag world and have them sit down not only with a couple of these key legislators, but then when you start looking at adverse possessions and section lines and everything, you involve a lot of players. County assessors, if you've taken, let's say that the fence is off by 50 feet, but it runs for a half mile, you're talking, 5, 6, 7 acres, and yet if they've taken it by adverse possession, the original person that, at least according to the records of the Register of Deeds office, is still paying taxes on it. And it seems to me that they have a legitimate complaint that if I'm paying the taxes but my neighbor owns it, that's not right. And you know what? That resonates. So we have to bring in the counties and the tax assessors, and then you've got all kinds of, let's take rural electric and maybe even some of the cable and telephone folks, that they always tended to follow fence lines, but if the fence lines didn't coincide with, let's say, section lines and quarter section lines, that's a problem. So they've got an interest in it. So I'm going to try to get everybody at the table and see if our bright, experienced lawyers, without giving up the certainty of having a statute of repose, which is what statute of that's what adverse possession is. It's simply if you've exercised control for 20 years, open and notoriously, then it becomes yours by operation of law. At least that's my interpretation of our Supreme Court's decisions. So we need to take a look at that. I don't think we should give up adverse possession because, particularly in municipalities, it resolves issues. But there's certainly room to talk. So I'm going to try to gather all these folks up together at the annual meeting in June and see if we can't finally put to rest something that preserves what we need, which is certainty in the law, at the same time address some of the equitable unfairness that can result. So that's what's coming with those two bills. Senate Bill 141, that was the counterpart to the child support that failed on the floor of the House. That's through the Senate now. It was amended. It's been 8 years. We're talking about a 4% across the board. That's what we all figured we could get done. And that went through House Judiciary on Monday of this week. This is Thursday. Maybe it was yesterday, I'm sorry. And yeah, it was yesterday morning. These are all a blur at this time of the session, you can understand. And that'll be up on the floor on Monday of the House. I think it'll do fine. There'll be some no votes, but I think it'll pass this time. Then we have Senate Bills 167. That's would require additional notices by our guardian to nearest relatives and so forth. And that one came out of Senate Judiciary. I offered a hog house on the floor trying to salvage something without doing harm, and the Senate adopted the hog house. This is the sequel, if you will, to last year's Peter Falk bill. And Peter Falk's daughter, Catherine, upon review of the hog house, was upset. She didn't like it, and she went back to her prime sponsor, Senator Jensen, said, I want it returned to its original form. To which I informed the senator that he could try that, but then the bill would die in House Judiciary. And he said, well, that's what I got to do. So that was heard on Monday, and we killed that bill. The corresponding bill, also sponsored by Senator Jensen, was Senate Bill 168, that would have enhanced the power and preserved the power of durable powers of attorney, even in the face of the appointment of guardianship or conservatorship. We killed that right in committee. You can only have one person operating the checkbook and paying the bills, and typically, as I explained to the House committee yesterday, in probably 95, 96, 97% of the cases, when you go formal guardianship but yet still have close family members alive, it's because the person holding the durable power of attorney has been doing things that irritate their siblings, and that's what results in something more formal along the line of a guardianship or conservatorship. And in any event, that was killed. So bottom line of all those bills, we passed what we needed to pass and we killed what we needed to kill. Now I want to go back to 1083. House Bill 1083 was voted on at the annual meeting in June. And we had a 3-year study of the task force appointed by the Chief Justice, trying to figure out what can we do. South Dakota is the only state that provided zero funding to augment legal services for the poor. And you folks all authorized that bill last June. And I brought it this January. Very, very difficult because it requires 2/3 and of both houses. We got 50 votes in the House. We needed 47, so we squeaked by there. I started working this bill even on the Senate side, because I knew that was going to be very, very tough, on the second day of session. And that came to a vote 2 days ago in the Senate. It squeaked out of committee 4-3, but on the floor we got 27 votes, 6 nays, and 2 excused. That's a big victory for our legal services programs, and generally speaking, for the poor people, our veterans, our disabled, our victims of domestic violence. Uh, Between the filing fee when on the petitioner side, uh, when you reopen a divorce or a custody case, uh, that brings in about $55,000 a year. This is $25 when you file an answer in circuit court or a responsive pleading in circuit court. And at $25, that will raise around 100, maybe 105. Depends a little bit. It's a little bit flexible because there is a waiver. If you're poor and being sued, the judge can waive it. You can file an answer. A lot of times, if you're going for child support adjustment, the plaintiff side may have that waived because they're poor, and the defense side probably is also poor. So the same standards will apply for a waiver. So we think between the two, the existing one and the new one, which will kick in July 1st, that we're probably going to have come available roughly $150,000 a year. That's enough money where the Commission on Equal Access to the Courts can actually consider grant applications that are focused, that emphasize help for not just poor in general, but in particular our disabled, our senior citizens on fixed incomes. Certainly our veterans are there. And we have Marcy's Law, which now requires notification by the prosecutor's office or law enforcement if, when's the abuser going to appear in court and so forth. Well, that's fine on the criminal side, but in the meantime, the victims are huddled in a shelter someplace. How do they get to work? Are they going to is the car going to be repossessed, and then they're out of a job? And so many times in abusive situations, you'll find that the victim has been isolated. They don't have access to the bank account, savings, checking account, credit cards, and so forth. And so they're at a loss. And while the shelters might be able to help them with a little food and a bed, what about their legal issues? And so they're a high priority for us too. So hopefully between what you folks do, which is your opt-out money, that allows everybody to participate. And then many of you have adopted the Bar Foundation as one of your favorite charities, and you send in more than the 75. You may notice in the newsletter we publish those people who belong to, they become a fellow of the South Dakota Bar Foundation. And those monies, those foundation monies, when you become a fellow, we don't just spend that money. We have an endowment fund up at the South Dakota Community Foundation. I'm not wise enough to be investing those monies. We go to the Community Foundation. That money has been salted away, and in perpetuity that will generate money to go to these types of programs and help those kinds of people. And that ought to be what the endowment ought to be able to do, is produce something between $50,000 and $60,000 a year. We're hoping that we can get that endowment up to the $3 or $4 million level, so that it too is generating, by South Dakota standards, significant money. Between what the foundation can do and what now the Equal Access to the Courts Commission can do, we look for a tag team where we're able to perhaps really put a dent and serve more people. The old South Dakota standard, we have to do more with less, still applies in this situation, but at least we're going to be dealing with several $100,000 instead of a fraction of that. My last word, if you're not a fellow, think about joining. Think about cutting that check and becoming a fellow. And if all you can afford is the $500, just join for a year. If you can afford, even with a pledge, you could become a permanent fellow at $5,000 and just give $1,000 a year. And you can start at any time during the calendar year, and your money will be there forever. And that's what makes the Fellows Program so important. I'll give a brief final update towards the end of next week. Right now, the the only thing left of a state bar bill or a supported bill is the child support update. That'll be on the floor on Monday, so I'll give you the final on that. Every indication is that the governor will sign all of our bills, and the big thing that's going on behind the scenes, and they're racing back and forth, is the legislators are trying to figure out how we're going to balance our budget when we have a roughly $50 million hole in our income or revenue, and that's not going to be easy. I don't relish that responsibility, but that's what's going to be going on over the next week. So have a great weekend, have a good week, and I'll talk one more time towards the end of next week. Have a good one.